Emergency alert for every gun owner in America. The Supreme Court just tore down a wall that stood for over 100 years, and most people have no idea it happened. Right now, in every single state, the rules for carrying a firearm just changed forever. Not in blue states only, not in red states only. Every state, all at once. And millions of Americans are walking around today with rights they didn't have 6 months ago, and they don't even know it. If you own a gun, if you're thinking about buying one, or if you simply believe the Constitution should mean something, what you're about to hear will change how you see your own rights forever. Here's what happened. The Supreme Court destroyed the system that let government officials decide who deserved to protect themselves and who didn't. For generations, if you wanted a concealed carry permit in certain states, you didn't just fill out paperwork. You had to convince a stranger behind a desk that your life was worth protecting. If they didn't like your reason, denied. No gun, no appeal, no real rights. That system is gone, dead, unconstitutional. And what replaced it touches every single person reading this, whether you live in New York, Texas, California, or Florida. Most people hear Supreme Court ruling and assume it's boring legal talk for lawyers in suits. It is not. What I'm breaking down right now is the difference between staying protected and legal or accidentally committing a felony because you didn't realize which rules changed and which ones didn't. Stick with me, because by the end of this, you will understand your own gun rights better than almost everyone around you. And if you want to keep catching updates like this before they hit the mainstream news, make sure you're following, because these laws are shifting in real time, state by state, and missing an update could cost you a right or land you in handcuffs. The case is called New York State Rifle and Pistol Association versus Bruin, decided in June 2022, a 6-3 decision written by Justice Clarence Thomas. This case did not just affect New York. It sent a shockwave through every state that ever tried to gatekeep the right to carry a firearm in public. For over a century, states like New York, California, New Jersey, Maryland, Massachusetts, and Hawaii operated under what's called a may issue system. May issue means exactly what it sounds like. The government may give you a permit, if it feels like it. An official could look at your application and say your reason wasn't good enough, your fear wasn't real enough, your life wasn't important enough to protect. Over 100 million Americans lived under that system. And for most ordinary people, the answer was almost always no. Picture it. You're a law-abiding citizen with a clean record. You apply for a permit to protect yourself and your family. A bureaucrat who has never walked through your neighborhood at night, never looked over their shoulder in a dark parking garage, decides whether your fear counts. General self-defense isn't good enough, they say. Denied. Not because you failed a background check, not because you're dangerous, because someone decided your reason wasn't compelling enough to let you exercise a constitutional right. That is exactly what the Supreme Court just ruled unconstitutional. And it's exactly why this decision matters so much more than people realize. 2 men in New York applied for concealed carry permits for general self-defense and were denied because the state said that wasn't a specific enough reason. They sued, and the Supreme Court sided with them decisively. Justice Thomas wrote that the Second Amendment protects an individual's right to carry a handgun outside the home for self-defense, and that law-abiding citizens cannot be forced to prove a special reason to exercise that right. Think about that in context. The government can't force you to justify your right to free speech. It can't make you prove your religious beliefs are sincere enough. Rights aren't privileges handed out by a mood. You have them. The government can regulate how you exercise them, but it cannot make you beg for them first. So here's exactly what died with this ruling. May issue permitting is unconstitutional. Full stop. New York's proper cause standard? Gone. New Jersey's justifiable need? Gone. California's good cause? Gone. Maryland, Massachusetts, and Hawaii's discretionary denial systems? All gone. What replaced them is called shall issue. That single word change is everything. The state shall give you a permit if you meet the legal, objective requirements. No more subjective judgment calls. No more proving your fear is real to someone else's satisfaction. Background checks, fingerprinting, and safety training can still be required, but the era of a bureaucrat's personal opinion deciding your fate is over. But there's something even bigger buried inside this ruling that almost nobody is talking about. Before this case, courts used a weak legal standard where the government just had to show a gun law was reasonably related to public safety, an easy bar that let almost any restriction survive. This decision throws that out entirely and replaces it with what's called the text, history, and tradition test. Now, if a government wants to defend a gun restriction, it has to prove that law matches the historical tradition of firearm regulation, going back to 1791, when the Second Amendment was ratified. If lawmakers can't find a historical twin for a modern gun law, that law is unconstitutional. Assault weapon bans, magazine limits, waiting periods, red flag laws, all of them are now being challenged under this new standard, and some are already falling. Now let's make this personal, because legal theory means nothing until you see how it changes real lives. Imagine a nurse working night shifts in a rough part of a major city, walking to her car alone at 2 in the morning, followed twice already, police unable to help. Under the old system, she applies for a permit and gets told her fear isn't special enough, denied. Under the new rules, she meets the objective requirements, passes her background check, and the state has no choice but to issue her permit. Or picture a small shop owner robbed twice in 3 years, employees threatened at gunpoint, documented police reports in hand, and still denied under the old subjective system because a bureaucrat decided he should just hire security instead. That excuse no longer holds up. If you meet the legal requirements, the government cannot override the Constitution because it personally disagrees with your reason. Here's where it gets dangerous if you're not paying attention. States that can no longer deny permits outright are now trying to make those permits useless. New York and California rushed emergency legislation labeling almost every public space a sensitive location, parks, transit, restaurants, and more, effectively creating legal minefields where carrying could still get you arrested. Some of these expansions are already being struck down in court. Others remain in effect right now. This is why you cannot assume this ruling means unrestricted freedom. Permitless carry was not mandated. Gun-free zones still exist. Background checks and training requirements are still fully legal. This decision changed who can be denied, not whether permits or restrictions can exist at all. This ruling didn't come out of nowhere either. It's the third chapter in a 15-year legal progression. One case established your individual right to a firearm at home. The next case forced states to respect that right. And this case pushed the right out into public life, while making it dramatically harder for any government to claw it back. The direction is unmistakable, and it isn't slowing down. Here is what you need to remember before you do anything else. If your state ever forced you to prove a special reason to carry a firearm, that requirement is now dead. If you're a law-abiding adult who meets your state's legal requirements, the government has to issue your permit. No exceptions, no personal opinions allowed. But ignorance is still a felony waiting to happen. You must check your local laws before you carry anywhere new, because sensitive location rules are shifting weekly in certain states. This is the largest expansion of self-defense rights in modern American history. And it happened because millions of people finally said their lives were worth protecting, permission or not. If this gave you information you needed today, share it with someone who carries, someone who was denied a permit years ago, or someone who has no idea their rights just expanded. Drop a comment with your state and tell me whether you've noticed any changes where you live. Stay safe, stay legal, and stay informed.